Hi everyone, I'm back. Okay, so the pretrial summary for today, Wednesday, August 24th, 2016. I'll go through it as quick as I can, try to give you all the details. I was there this afternoon for 6 hours. There was about an hour and a half, hour and 45 minutes that I missed towards the end because I left. But this is what I know from sitting in on the pretrial conference. The morning began with the prosecution objecting to testimony from Dr. Angus Perry McIntosh II, an expert called upon by Shauna Cox, who believed that the doctor's testimony would help the jury understand their beliefs and perspectives on why they were disputing the arrest and twice convictions of the Hammonds and the occupation at the refuge in Oregon in January 2016. Dr. McIntosh has over 16 years of federal service working through the western states, primarily for the United States Forest Service and the Natural Resource Conservation Service as a range conservationist and range land management specialist. He left the field and pursued his PhD. He's considered an expert in the private property rights, having conducted over 60 seminars and workshops on the valuation of property rights in the western states, on federal land and split estate ranches. Dr. McIntosh is admitted as an expert witness in federal courts and has given expert testimony and reports in the federal district courts of Arizona, Colorado, Nevada, and the United States Court of Federal Claims. He has also given testimony before the state legislators of Arizona, New Mexico, Montana, Nevada on water rights, range management, and federal regulatory impacts on property rights. In court this morning, he suggested that the ranchers and federal employees often use words like permit, allotment, and public lands without knowing what those words really mean. As a result, they often use them interchangeably, and they do not mean the same thing, nor do they mean what people think they mean. His testimony in the Patriots case, according to prosecutor, was irrelevant to the case. Judge Brown made it very clear first thing this morning that she was there to determine the facts of the case and not argue law. Shauna Cox believed that the doctor's testimony would verify her beliefs for being at the refuge and participating in the protest in Burns, Oregon in January 2016. His expert testimony was heard via telephone this morning, and after a 15-minute recess, Judge Brown determined that the testimony would not be heard by the jury. Standing objections were noted by the judge, apparently because several attorneys have objected about it. So she makes sure that the court knows that she's fully aware of all these objections, but she said that at this time his testimony will not be allowed, but could be reconsidered later if new points were raised. And just for good measure, Ryan Bundy's attorney objected. Although this video is not the testimony heard this morning from the expert witness, the interview that you can find the link below in the description box, this interview that Dr. Angus did, it does cover some of what the doctor spoke of in the court conference via telephone this morning. He also describes the definition of public land, the concept of split estates, where the government may have some ownership or claim on a piece of land or a claim to minerals. It does not, but the government doesn't own everything pertaining to that land. Some rights or claims are owned by private citizens. The expert references the 1909 Act and the 1933 Grazing Act. He also quoted the Watt case, where ownership of land was established through purchases or leases, and that was the common thing throughout 1916. You can listen to the K-Talk radio interview of Dr. McIntosh. The link is below in the description box. But like I said, the judge is not going to allow the testimony at this time. And then we took like a 15-minute recess. You know, we come back and she said, no, I'm not going to allow the testimony. And then she moved on to evidence being presented in the co-conspiracy charges. And David Fry's attorney requested specifics. They need to know exactly what comments and who they refer to. The judge clarified, asking the prosecution for dates, exact comments, and who is the author of it. And also noted that David Fry's attorney also noted that his client did not even show up at the refuge until January 8th of 2016, and therefore could not be deemed a co-conspirator because he wasn't even there in January or prior to that date. He also contended that according to law enforcement and federal officials, comments made by Ammon Bundy in December on social media sites were, according to them, false statements and propaganda, but are now using those comments to justify the co-conspirator charges against his client. The judge called for a lunch break, which gave us all a needed nicotine, caffeine, food, and bathroom break. The defendants and counsel met together for 5 minutes before taking a break of their own. And when we returned, claims by Ammon that were discussed, prosecutor talked about that Ammon Bundy made some claims in November and December. One was that the FBI were going to raid the Bundy Ranch, and two was that Dwight's life was in danger if he continued to have contact with Ammon Bundy. Federal officials are saying those are both lies, but yet they're using those as proof that there was a conspiracy began clear back in November, December 2015. Pete Santilli did have Ammon on his show in December, as I recall, in which Ammon claimed the Hammonds were threatened if they had further contact with Ammon. I do remember that interview that Pete had. Prosecution contends that the conspiracy against federal employees began as early as November 2015. I find it, my personal opinion, I find it difficult to see how the charges of co-conspiracy will even stick, since none of the defendants were present during the conversation with Ryan Payne, Ammon Bundy, and Sheriff Ward. And a lot of the threats made, Sheriff Ward said they were made to him by Ryan Payne or Ammon Bundy. And but the rest of the guys weren't in the room, from what I can gather from the information. So I'm not sure how, like, David Fry would be considered a co-conspirator if he wasn't in the room making that argument with them. And I believe his attorney is saying the same thing. He wasn't there. He didn't know. He wasn't privy to this information. So prosecution also contended that Sheriff Ward made a statement about another threat that was made to him, but he couldn't say who in the crowd said it. David's attorney cited the U.S. Supreme Court case U.S. versus Mouzin, M-O-U-Z-I-N, of 1986, that stated that the witness needed to know who said it if the evidence was going to be used. Other evidence of conspiracy included emails that were obtained through a court order, as well as comments made to Sheriff Ward by Ammon and Ryan Payne, along with comments posted on Ammon's Facebook page on November 19th and a couple of them in December 2015. And the prosecutor also said there was a statement made by Shauna Cox on March 25th, 2016. So that comment would actually be made after she was already indicted on these charges. There was also a video posted on YouTube of Jason Patrick, John Ritzheimer, Blaine Cooper, and someone else, I can't remember, asking militia to join them in Burns, Oregon. I remember this video when the prosecution mentioned it, because I was questioning if it was recorded in front of a green screen. I did ask Blaine in the comment section below that video to verify that they were actually in Burns. But apparently the prosecution is also going to be using that video to prove that there is a conspiracy and that all of the defendants were involved as co-conspirators. One of the comments the judge is allowed to use, one comment the judge is allowing to be used in the trial was made by Ammon Bundy on his Facebook page on December 3rd, 2015, when responding to a question by, I believe the name was Brandon Thompson, asked Bundy several questions. I'm not specific about the comment that Ammon made in responding to him, but the assistant counsel to Shauna Cox, because Shauna Cox is pro se, but she's having a counsel aid her in her defense. She noted her objection because the content leading up to Ammon Bundy's comment was lengthy and covered a wide variety of topics not relevant to the case. She believed allowing the use of that single comment would be prejudicial. But the judge was still going to allow it. So I left the courtroom at 2:15, 2:20, something like that. And that's pretty much what they were still arguing about, was the content of these comments and what would be allowed and what wouldn't be allowed. So that's all I have. I will be there tomorrow covering the evidence, listening to the evidence that's going to be presented or be tossed out or whatever, and I will keep you guys updated on what I hear. Okay, have a good night.